On page 93 of your materials is a sample resolution for your rule enforcement procedure, and I'm running out of time, so we're going to just go through this relatively quickly. But it talks about, this is a reasonably good sample resolution on what your hearing should entail. And what you want to do is you want to have it consistent so that the people who are deciding whether or not rules have been violated are applying the same standards, and that people understand what they can do to present evidence with respect to their rules violations. Ordinarily, the only issue in a rules violation is going to be whether or not the rule was violated. But sometimes it's going to be appropriate, Judge Benson, the Christopher trial the Christopher trial notwithstanding, to listen to why people did or didn't do what they did. I don't know if any of you heard about that, but the Christopher, who was the guy who monkey wrenched the hearing, wanted to present a defense that his motives were civil disobedience. The judge said in a rather classic statement in front of the jury, in admonishing one of the criminal defense lawyers, the issue isn't whether he did it, it's why he did it. No, it's not why he did it, it's whether he did it. That's the only thing the jury is going to consider. That's what the judge said in that circumstance. And that's oftentimes going to be the issue that your association is going to face. But occasionally there are going to be issues that are important to consider in connection with rule violation. For example, if it's an architectural violation, you're going to have shades of gray as to whether or not it's an architectural violation. Somebody is accused of making a modification to their home that allegedly violates an architectural restriction. Your rules committee may need to determine whether or not what they did, say painting the eaves, is within the scope of control of the association. So you may need to do that. So your rules enforcement proceeding is going to set forth exactly what they're going to consider. So they can, just like the judge had to do in that case, decide what evidence is going to be relevant. A couple of other things to keep in mind in your rules enforcement. You're going to want people to feel comfortable to present at those hearings. So you're going to want to let them know, what kind of evidence they can bring in. Can they bring in witnesses? How much time will they have? Can they bring in a lawyer? I think if they're going to bring in a lawyer, your rules enforcement ought to say, you can bring a lawyer to the rules enforcement hearing, but we're going to want to know 24 hours in advance if you're going to do so. Because you as an association don't want your rules enforcement committee to get caught with a crafty lawyer on the other side and no lawyer on your side, and all the confusion that arises there. If you have 24 hours notice, you can at least talk to your association lawyer and decide whether or not it makes sense for you to have your association lawyer there. Hopefully it's not, because I don't think that these rule-making proceedings should be that formal. You're not trying to penalize people, you're trying to get people to comply with your governing documents. A few other things in this sample resolution that I think are worth note. This resolution does allow, and I think it's a good idea, to allow people, even at the letter stage, to take care of the problem. If you fix X, Y, or Z before the hearing, we don't need the hearing and we won't fine you. Because ultimately that's what you want. Ultimately, when you're enforcing your rules in your association, you're not trying to penalize people. You're not trying to get revenue off of fines. I agree with Michael, that's not a good idea. You're just trying to get people to comply with the rules. But ultimately, the purpose of rules and rule enforcement should be to create community. And if you're harassing people about minor violations and fining people when they immediately correct things, it's not going to help community and it's not going to help in enforcing. It really doesn't help to make an example of somebody if you don't need to make an example of them. Last thing I want to mention on the rule enforcement hearing is whether or not the rules enforcement committee should make a determination in the presence of the person who's charged. And my recommendation on that is generally, is universally not. I think that they should hear all of the evidence. They should thank the person for coming in, that they should tell the person that they're going to deliberate, tell the person how they're going to find out the results of the hearing, and then they go into session to discuss that amongst themselves. I mean, it may be a foregone conclusion at the end of the hearing what's going to happen. That having been said, I think it's still best to allow the process, to allow the rules enforcement people to go back, talk about the options, talk about what the sanctions ought to be in private, and then let the person know. Let the person know when they're going to hear, how they're going to hear, and then comply with that. We lawyers who have these disputes have clients, and they always ask us, when's the judge going to make the decision, and we always say we never know. I had a trial back in November. The judge promised that he would have a ruling by December 31st. I haven't heard anything yet. It's driving my client absolutely insane. And it's unfortunate that he said that because it created an expectation for her. Starting on about December 28th, she was calling or emailing me about every 3 hours. Have you heard yet? Have you heard yet? Have you heard yet? And I kept telling her, well, I think I'll hear by the 31st, but there's no guarantee because he's a judge. There's not much I can do if he doesn't make that determination. But it's still not good for her as far as her confidence in the system. Any questions about rules or rule enforcement?
Yeah, so kind of bringing in, real life example, you talked about like people bringing in their garbage can by 8 o'clock, right? So then in this subsection 2, it talks about, okay, if you're going to assess a fine, you have to notify the owner that they violated it and then inform them a fine will be imposed, but you have to give them 48 hours to remedy it. So if the whole point is that people have to bring in their garbage can next morning, when you put out the notice, does that mean you have to give them another 48 hours to bring in their garbage can? I mean, and then that happens every week, or how do you apply this?
In the policy we've adopted to deal with that, we have, notwithstanding this, we have adopted certain things that are immediate violation, and they have to be cured immediately, or the association will enforce. The issue there is, and I'm trying to think of an example. There's safety issues. Parking in a fire lane is an example. If you're parking in a fire lane, the association can act, can tow your car, and can fine you immediately. And then we don't impose the fine as a lien for that first violation. So in other words, first violation, the association acts immediately, but they don't impose the fine as a lien, but in connection with, by the way, your car's been towed, this is why it's been towed. If it happens again, after 48 hours, it's going to be an immediate fine. So that first instance is the 48-hour notice. Because I don't really know how else to get around that 48-hour notice, except sort of to give them a pass on the lien for the first violation, whatever it is. I wish the legislature would have said, unless it's something that needs to be immediate. But going back to the garbage can example, that's probably a better example than the tow. I would say that you fail to bring your garbage can in, future violations will be an immediate violation. If you don't do it, you will be fined immediately. Because you're really giving them 48 hours notice. It may be the next week that they don't bring the garbage can in, but they're getting more than 48 hours. They've had a week's notice to know that next week they have to have the garbage can in by a certain time. So I just deal with that in that instance where it's a 48-hour thing. Usually, though, you're going to want to give them 48 hours notice because you're going to either talk to them or do the thing hanging on their door before you post the fine. So you can knock off the 48-hour requirement by telling them that first time and you never ever be told. And I think that's sufficient. That's the trick, is you just gotta be able to say the person had notice.
Yeah, you can do the same thing with like your dog or just whatever. I mean, something that's going to happen over and over. Give them a warning the first time and then start.
I think if you got challenged on that to a judge, you could say, look, Judge, the purpose of this was that the legislature just wanted everybody to have notice of the individual notice that they were doing something wrong before they got fined. And if it's a garbage can and you tell them on March 5th, and they do it again on March 12th, I think they've got notice. You can say it's perfectly appropriate to fine. Any other questions? Yes?
Do posting signs as warnings, does that counteract that 48 that notice of the violation?
I think if you had a sign, I would still go through the process of an individual notice to. A good example of that would probably, the best example of that's probably either in this gymnasium or the pool, where you have things that, no diving. Somebody dives, I think you're probably going to have it. It probably doesn't need to be in writing, but it needs to be somewhere that Daybreak's lifeguard told these people on such and such that, diving will result in a fine. And then, I mean, the concern there is they do it 4 hours later. Presumably you can't find them at that point in time. You could probably kick them out or use something else like that. I mean, I think the other thing is, ultimately we have to hope that these enforcement things will be reasonable. If somebody's creating something that's a dangerous situation, I don't think a judge should get hung up over the fact that you didn't give them 48 hours to, get their car out of the fire lane or whatever.
What if you're just parked in a reserved spot?
If you're parked in a reserved spot, I think you could give them 48 hours notice, and then fine them after that. Fine them and leave them.
Cannot tow immediately.
I can talk for hours about towing and whether or not you should tow, but I'd be very careful to tow without having a documentation of the notice, because you've got to make sure that the person who's parking the car there owns the car, that they have control of the car, all those sorts of things. You don't want to tow somebody's car that their 16-year-old parked there without them knowing that their 16-year-old car parked the car that they had an opportunity to do it, because that's where you get sued for wrongful deprivation of property. That's a good thing. So you want to make sure that you can defend the action. And in fact, I'm quite leery about having associations tow cars. We don't have time to talk about that. Just make sure your towing company has good insurance. And they will indemnify you if they tow the wrong car. That's the quick answer there. Any other questions?